हाँ
Yeah, put it on silent mode without vibrate.
मेरा
Without
फ्लाइट पे है वैसे भी
नहीं नहीं,
थोड़ा सा
व्हाट्सएप
व्हाट्सएप
मैसेज आते हैं।
नोटिफिकेशन
नहीं अभी पूरे साइलेंट रखे आते हैं।
नहीं नोटिफिकेशन बंद करके छोड़ती हूँ व्हाट्सएप मैसेजेस हाँ सर स्नैपचैट तो बंद ही है फैन नहीं ऊपर का एसी चालू है
नहीं इधर है।
वो आनंद सर ने लाइब्रेरी का ऑन रखा है सतीश सर आपका ये चालू है आप ये लॉक करके रखोगे तो चालू ही रहेगा
संतोष
Attention, ladies and gentlemen, judges will arrive in 5 minutes. So please maintain the decorum of the hall. Kindly put your phones on silent mode. We do not want anybody's phone ringing in the middle of the session. And this event will be streamed live on YouTube. There will be one camera here for the mooker. So anybody walking across, our students specifically, make sure you don't unnecessarily go out and come inside the hall because they will be seen in this camera and it won't look good. So please keep this thing in mind. Thank you. This will come in 5 minutes.
This is the final hearing in matter of Radharani and others versus Union of India and another. Petitioners are represented by 27, respondents are represented by 28. May the session begin, my lords. The court is now in session. Yeah.
Greetings to the bench. Council seeks permission to refer the bench collectively as lordships.
Yes.
Much obliged, lordships. May I please this honorable court? This is Speaker 1 appearing on behalf of the petitioners in this case, my lord. In the case of Pratap Yadav versus Union of India, Radharani versus Union of India and Watchman, the doctor versus Union of India, and Priti versus Union of India. My lords, this council will be dealing with two issues, the first two issues, and my co-counsel will be dealing with the next two issues, your lordships. The council would like to humbly request the lordships to kindly grant me 20 minutes to address my issues, and my co-counsel will be taking another 20 more minutes, and we would like to reserve 5 minutes for the rebuttals exclusively, my lords. Much obliged. Your lordship, this council will be dealing with two issues. The first issue pertaining to does a woman have a constitutional right whether to retain or termination of pregnancy with regards to this particular case, and the second issue, the council will be contesting the constitutional validity of Medical Termination of Pregnancy Act of 1971 along with Section 312 of the Penal Code, my lords. May the council move on to the first issue, my lords?
Yes.
Much obliged, your lordships. Your lordships, moving on to the first issue, whether women have a constitutional right to retain or terminate a pregnancy. Your lordships, we all are aware that Article 21 of our
We
Constitution.
are not aware.
Much
We are
obliged, your
not
lordships.
aware about the constitutional right of a woman.
It is the duty of this council to
Yes.
illuminate the bench then.
Yes.
Much obliged, your lordships. Article 21 of our Constitution, your lordships, states that no person shall be deprived of his personal life or life or personal liberty, except in the case where due procedure established by law. And also, your lordship, Article 21 further states that this due procedure, which is established by law, needs to be reasonable, fair, and non-arbitrary, my lords. In this instant case, your lordship, the council would like to invite your lordship's kind attention to page number 17 of the petitioner's memorial, my lords. If your lordships are with me, the council would like to proceed, my lords. Much obliged. Your lordship, in footnote number 12, my lords, in the case of Sarmishta Chakraborty versus Union of India, the court stated that the right of a woman to have reproductive choice is an integral part of her personal liberty, as envisaged under Article 21 of the Constitution. For
Reading page number 17.
indeed, my lord, page number 17 of the petitioner's memorial, my lords.
Are we having? Page 17, it appears.
But he's 18. You are reading 18, page number 18, right?
Apologies, kind of apologies. In the council.
Para number 12, you said.
No, my lords, page number 17 of the petitioner's memorial, footnote number 12, wherein the council had cited. Exactly, indeed, your lordships. May the council proceed, my lords?
Yes.
Much obliged, your lordships. In the case of Sarmishta Chakraborty versus Union of India, the court stated that the right of a woman to have a reproductive choice is an integral part of her personal liberty, as envisaged under Article 21 of the Constitution. Further, your lordship, the court stated that she has a sacrosanct right to have her bodily integrity, my lords. Your lordship, personal liberty with reference to this particular case at hand would infer women being able to take decisions regarding their whether to retain or terminate their pregnancy in a free and absolute manner, my lords. The council would also like to
21 uses a positive obligation right to life is a negative right or a positive?
Positive.
So now you are asking for termination of a life.
Indeed, your lordships.
So how can you ask for a negative right and for positive?
This particular council's argument is constrained to right to life, which extends to women in this case, my lords. And the council would like to.
That's what exactly I'm asking.
Indeed.
Article 21 gives you a positive right for life.
Indeed, your
It
lordships.
doesn't give you a negative right to die.
Indeed, your lordships.
Then you are asking us to
Indeed. Your lordship, this particular aspect, your lordship, it needs to be considered whether unborn child can be, whether the right to life will extend to unborn child or not. Only with regards to that aspect can we say that it can be determined whether a right to life is affected for the unborn child or not, my lords. But before going into that particular ambit, indeed not, my lordship. The council like to clarify this. Council is representing Pratap Yadav, my lordship, the petitioners. Shakuntala Devi is not a party to the dispute, your lordship. It is Pratap Yadav who filed the instant writ petition under Article 30.
Yeah, but
it's one of the cases, my lordship. It's one of the cases.
So you could have challenged even the power of the election commission to make such
Your lordship, the imperative reason why this council had preferred to bring it under Article 21 is, my lord, because Article 21 confers a direct fundamental right, my lord, which is an imperative right. Fundamental rights as
no, you could straight away question the action.
Your lordship, due to the further argument, the council will be contesting the same as well, my lords. But this particular issue would be focused upon the constitutional right of women being a fundamental right, your lordship, with regards to retaining or termination of the pregnancy, my lords. If your lordships are satisfied, the council would like to proceed with the arguments.
One question what I would ask you is,
Indeed.
fundamental right under Article 21 you're saying.
Indeed.
Fundamental right for the fetus also is available.
Indeed, your lordships.
So as per you, you're saying it's a human right for a woman to abort the fetus or not. It's her personal liberty.
Fundamental, yes.
Fundamental.
Indeed.
Does Article 21 specify such things? What does Article 21?
Your lordship, this particular presumption of law, which is to give more predominance whether to the right of life of the woman or to right to life to the unborn child. Exactly, my lord. It was stated in the case of Roe versus Wade, my lord, wherein they highlighted the viability time period itself, my lord. They stated that beyond 24 weeks, my lord, more predominance and more discretion should be given to right of the unborn child. But my lord, prior to 24 weeks, it is the right to life of the mother which will have more predominance, my lord, over the right of the unborn child.
Between 18 weeks to 24 weeks,
Indeed, my lord.
the heartbeat of a child is already in existence.
Indeed.
There is a conceive of this fetus.
Indeed.
After the heart starts beating, it means there is a life in the child,
Indeed.
in the fetus.
Indeed.
So, liberty of a fundamental right to abort the child.
Indeed.
Does this Article 21 specify?
Your lordship, Article 21 on the face of it, it doesn't explicitly hold this particular right, my lord. But what the council would like to humbly put forth to this honourable bench is that, your lordship, with regards to retaining of pregnancy, my lords, woman has the right to procreation and right to reproduction under Article 21, my lords. No law can say that you cannot, no law can dictate a woman saying. Indeed, your lordship. Indeed, your lordship.
And because you voted over.
Indeed, my lord.
If you take the new changes that happened in US 2021, Texas has passed a law called Texas Quantity Act.
Indeed, your lordship.
Which says, you have any idea about that?
The council is currently unaware of
It says that after 6 weeks, the fetus heartbeat could be identified by the doctor.
Indeed.
It can terminate. The American Supreme Court refused grant amnesty.
Indeed, your lordships.
Under certain disabilities.
Except in case of disability, not even rape, nothing.
Indeed, my lords.
And this was passed even in Georgia, Ohio, and others.
Indeed, your lordship. Your lordship, as time evolves, time changes, your lordship. Law consistently evolves and changes with time, your lordship. We have seen various pronouncements.
What madam asked is the same thing I'm asking. Heartbeat.
Indeed.
That means the child is viable.
Indeed.
Once the child is viable, it is right of the mother to take.
Your lordship, this particular point, whether the right to life of the woman or right to life of the child, which would have more predominance, depends on case-to-case basis. There is no a proper guideline or directions as to which will, or there is no circumstances under which will dictate the term as to whose right will prevail or whose right will have more predominance. This is an evolving law, my lords, in this regard, which is why the council, your lord.
So you interest us that the mother life is more important than the child.
Indeed, your lordships. Indeed, your lordships. The council later humbly contend that, your lordships, in the case to save the life of the mother, your lordships, in that particular case alone, having. Indeed.
What you are asking now, all the cases representation.
Indeed,
Not to save her.
Indeed, Your Lordship.
But in fact, for their own personal benefits.
Indeed, Your Lordship.
Interest of that woman.
Your Lordship, personal benefits, all these rights are fundamental rights, Your Lordship. The imperative reason why the petitioners Radharani and Preeti had approached the jurisdiction of this honorable court is it's because they want to work, my lord. Radharani has got a prospective job in abroad, my lord.
As we understand is Shobha Rani, right?
Radharani, my lord.
Radha Rani is a lady who wants, she's a great aspirant. She was working in some company and she has got some prospects abroad, job opportunity abroad.
Indeed, my lord.
And insofar as one more lady, who is this?
Shakuntala Devi, my lord. She wants to contest in the elections.
Contesting the election, and her prospects also were very bright. And then she wanted abort, the fetus to be aborted.
Indeed,
And
indeed.
insofar as the third person is concerned, same thing again. Where is the disability of anything harm to the life of the woman due to the
Indeed, my lordships. Indeed, my lordships. Your lordship, the council had to clarify on this particular regard, your lordship. But right to work is also a fundamental right, has been enshrined in Article.
right of
Your
work? We are
lordship,
not
much apologies, my lords, much apologies. Article 19, clause 1G, my lord, right to freedom to practice and propagate profession in a free and a manner, my lord. This fundamental.
What are the reasonable restrictions?
Reasonable restriction, it states that 19 clause 6, my lord, it states the reasonable restrictions.
What are the grounds?
Or the grounds says loss of the land, my lord. Or the loss of the land. Any statute that
19 clause.
also the council is currently unavailable with the
just
barracks.
you must be having the constitution.
We are currently unavailable.
You should come with the books.
In the public interest, they can impose restrictions. They can impose restrictions on application.
Indeed.
Respond to Article
Indeed,
19 clause 6.
Indeed, my lord. Thank you. Indeed.
So therefore, in the public interest, restrictions can be.
Exactly, my lord. Restrictions can be imposed. No fundamental right is absolute, my lord. All the council right to confirm is that such restrictions must be fair, reasonable, and it shouldn't create an undue burden on the part of whom the right is conferred from freely exercising the right.
Let us look into this.
Indeed, my lord.
You quoted point Q.
Indeed.
It says the procedure established.
Indeed, my lord.
So what is the procedure established by law is violated according to you?
Your lordship, in this instant case, the procedure established by law is the Medical Termination of Pregnancy Act of 1971, my lords. Your lordship, that itself is a procedure established by law, my lord. The council would like to humbly state that there is no nexus between the object of the act and the provisions of the act, my lords. That is one of the ambit in which the council will be arguing when it's addressing the second issue, my lord. The council will be contending the constitutionality of the second issue, my lord. Much obliged. Your lordship, the council would like to place its reliance upon the landmark judgments of K.S. Puttaswamy versus Union of India and Suchitra Srivatsava versus Chandigarh administration, wherein the courts has explicitly recognized the constitutional right of women to make reproductive choices as part of a public liberty, a personal liberty, my lord. Much apologies. And the courts went on to held that a woman's choice to bear a child or to opt for adoption covers the dimension of personal liberty, my lords. Your lordship, the council would also like to place its reliance upon the case of High Court on its own motion versus the state of Maharashtra, wherein the Bombay High Court held that the pregnancy takes place within the body of a woman and has profound effects on her health, mental well-being, and life. Thus, how she wants to deal with this pregnancy must be a decision she and she alone can make. The right to control their own body and fertility and motherhood choices should be left to the woman alone, my lord. These are all the various judicial pronouncements in which it was held in such a manner, my lord. The council would also like to state that, my lord, right to health, my lord, being one of the facets of Article 21, also extends to women in this particular case with regards to retention or termination of a pregnancy. The council would like to quote the case of State of Punjab versus M.S. Chawla, wherein the very apex court had held that right to health will be included under Article 21. Your lordship, it is a humble contention of this council that women should have absolute control over her body and the choices with regards to her body, my lord. The main reason is that in the case of M. Nagaraj versus Union of India, it was held that if a woman does not want to continue with her pregnancy, then forcing her to do so represents a violation of the woman's bodily integrity and aggravates a mental trauma, which would be detrimental to her mental health, my lord. Your lordship, to provide further clarity to the issue, my lord, the council would like to read the verbatim of the first issue again, my lord. Does woman have constitutional right to retain or terminate her pregnancy? Yeah, Lordship, the council would like to divide this particular issue in two parts, my lord. As in, does woman have a constitutional right to retain pregnancy, and does woman have a constitutional right to terminate her pregnancy? Yeah, Lordship, with regards to does woman have a right to retain her pregnancy, as was already stated, right to procreation, right to reproductive choices, reproduction, all extends to women in this particular case, my lord. There can be no law or there can be no person which prevents a woman from having a sexual intercourse or which prevents a woman from being pregnant, my lord. That is a humble submission of this council. Moving further with right to termination, my lord, with all these judicial pronouncements, time and time again, the courts have clearly held that women do have a right to terminate the pregnancy if it is detrimental to their mental health or if it is detrimental to their life, my lord. With this contention, the council would like to humbly submit the first issue by contending before this honorable bench that women should have absolute control over body with regards to both retaining a pregnancy and also with regards to termination of a pregnancy, my lords. If you
Termination, her exclusive right.
Your Lordship, at the current scenario, it isn't because it is restricted by Medical Termination of Pregnancy Act. But Your Lordship, in the next issue, the Council would be contesting the constitutionality of Medical Termination of Pregnancy Act, whereby saying it is unreasonable. And once if the
Yes, continue.
Indeed, my lords. Once if the courts uses its wisdom of judiciary, if to decide medical termination of pregnancy act may be unconstitutional, then it will become absolute, my lord. Now the current position of law is that it is an absolute, my lord. May the council proceed to the next issue, my lords. Much obliged, Your Lordship. We're also moving on to the next issue, my lord, whether a medical termination of pregnancy act, or the council like to divide this issue into two ambits, my lord. The first ambit, the council like to focus upon the constitutionality of the medical termination of pregnancy act of 1971, and the second ambit, the council like to touch upon the constitutional validity of section 312 of the penal code, my lord. Your Lordship, moving on to the constitutionality of Medical Termination of Pregnancy Act, the Council would like to further divide this issue into three parts. The first part would the Council would try to establish the fact that there is no nexus between the object of the Act and the provision which has been incorporated under said statute, my lord. The second contention, the Council would like to state that this particular Act, it violates fundamental rights which has been guaranteed under Article 19 and Article 21, my lords. The third ambit, the council would like to state that there is a lack of legislative competency for enacting this particular statute.
What is the connection of excessive?
Your Lordship, that is a separate ambit, my lord. If a law is inconsistent with Part 3 of the Constitution or any other laws in force of the state, it is deemed to be struck down as unconstitutional. The Council, during its second part of the argument, would like to contest that this particular act is in direct contravention to Article 19 and 21, whereby, for this particular reason alone, it needs to be struck down as unconstitutional, my lords. If your Lordship's permit, the Council like to move on to the first limb of my argument. Much obliged, Your Lordship. Your Lordship, moving on to the first limb of my argument, there is no nexus between the object of the act and the provision which has been enshrined, which has been incorporated under the same statute. The council would like to, before moving on to the crux of the argument, the council would like to illuminate the bench regarding the object of MTP Act, my lord, the Medical Termination of Pregnancy Act. Your Lordship, in the case of Vijay Sharma versus Union of India, it was stated that the legislative intent of the Act is to allow a certified medical practitioner to terminate a woman's pregnancy if the pregnancy posed a serious risk to the pregnant woman's life or a physical or mental health. Your Lordship, with this judicial pronouncement, my lord, it can be inferred that one of the imperative objects of Medical Termination of Pregnancy Act is to give due regards to the life of the woman, my lord. But what happened in this case is that the council would like to direct your lordship's kind attention to section 3 of the Medical Termination of Pregnancy Act, my lord. If your lordships are with me, the council would like to proceed, my lords. Much obliged, lordships, much obliged. Your Lordship, Section 3 states that when pregnancies may be terminated by registered medical practitioners, and it states that notwithstanding anything contained in the penal code, a registered medical practitioner shall not be guilty of any offence under the code or under any other law for the time being in force if any pregnancy is terminated by him in accordance with the provisions of this Act. Your Lordship, Section 3 prescribes the procedure under which a woman can prefer abortion with the help of the medical practitioner. This is the heart of this particular statute, the entire statute itself, my lord, along with Section 4 and Section 5, your lordship. This Section 3, which provides various procedures for women to undergo an abortion. Now, when we take a look at the verbatim, the words.
Kindly read the proviso to Section 3.
Indeed, my lords.
The length of pregnancy exceeds 12 weeks.
Indeed, my lord, the captain, the council is coming to that, my lord. The council is trying to establish that the verbatim of section 3 or the words that the legislature used to draft this particular statute, my lord, it is not in consonance to the object of the act. As was
Does the act give you objects? The 1971 Act.
indeed, my lord, it does give me objective. May the council proceed to the objective, my lords. Indeed, my lords. It's there the starting of the act, my lord. If I may be able to read. Definitely, my lord. Much obliged. An act to provide for the termination of certain pregnancies by registered medical practitioners and for matters concerned therewith or incidental thereto.
So why you are saying that?
Your lordship, this act was formulated in the year of 1971, my lord. And all these judicial pronouncements came after.
You think that the objectives of the act is beside the virus of the act?
Indeed, your lordship. There should be a reasonable nexus between the object of the act and the provisions of the act itself.
We would look into whether the provisions of the act violation.
That is all.
The objective is a very laudable objective, but your opposition is actually going to.
Indeed, your lordship.
Then we won't argue.
Your lordship, the doctrine of severability, your lordship, it states that when a particular provision, any single provision or any provision which is inconsistent with the object of the act, and if we pull out the particular provision from the statute.
What kind of interpretation? That the objectives will supersede the provisions.
Your lordship, this would call upon for test of reasonableness and doctrine of proportionality, your lordship, which states that.
Reasonableness depends on
Indeed, your lordship, but doctrine of proportionality, it depends on the object, my lord, wherein, your lordship, doctrine of proportionality states that the legislative action in this, with regards to this case, the legislative action should be in consonance to the actual action that the legislation is bringing up, your lordship. Also, with this, the council would like to humbly state that Section 3, your lordship, the verbatim of Section 3 is clear that it only allows, your lordship, if the council may have grace time of a minute to.
I have another 2 minutes.
Much obliged, your lordship, much obliged. Your lordship.
You have to conclude in this 2 minutes.
Indeed, your lordship, indeed.
And what is your prayer?
Indeed, your lordship, indeed. Your lordship, the council would like to move on to the next limb of the argument, whereby stating that legislative competency, your lordship, the legislature do not have the competency to enact this particular act. My lords, when we take the 7th schedule of our constitution into account, my lords, this particular power of the legislature, my lord, is not conferred with the, it doesn't come within the part of the union list, but rather it comes a part of the state list, my lord, under Rule 6, my lord.
Then what prevails?
Sorry, my lord?
What prevails? Union and Central Act prevails or the State Act prevails?
The Central Act, my lord. My lord, they do not have the power to make such a provision, my lord, because under the central list.
It has been given a directive principle by the Constitution.
Indeed, my lord, but the council would like to clarify that directive principles of state policy must be given due regard, but it is not an enforceable right, my lord. But rather, the provisions of the Constitution are an enforceable right. When there is a conflict between the directive principles of state policy and any other constitutional right or a fundamental right, the courts will resort to the maximum possibility of harmonious construction between the two conflicting statutes. But in case the harmonious construction fails, it is obviously the fundamental rights or the constitutional rights which will have more predominance over the directive principles of state policies, my lord. With this, my lord, the council would like to quote that the union, the parliament, my lord, the central parliament, they do not have the competency to enact this particular enactment, whereby this attracts colorable legislation, my lord. Colorable legislation dictates that when the legislature, when they have insufficient capacity, power, or when they have absolutely no authority, and when they overuse their authority, my lord, in that case, it attracts. Indeed, my lord. Apologies, my lord.
Tell me, the Medical Termination of Pregnancy Act was passed under which entry?
Which entry? Your lordship, it was passed by the parliament, or the central parliament, but it was supposed.
The parliament passed under which entry?
Union list, my lord.
Under union list, there are 90.
97, 97.
Which one of them?
My lord, the council is currently unaware of that, my lord.
If you are unaware, how are you saying that the parliament has no power?
Because, my lord, there is I explicitly mentioned in entry 6 of the state list, my lord, which says that right to health and sanitation, my lord. It is clearly given. Entry 97 only states that any list which has not been mentioned under the.
were passing an act, there was no mention to what degree that it was.
Indeed, my lord. Indeed. My lord, apologies, my lord, on behalf of the. My lord, but all the council is trying
So
to.
therefore, we will not be able to accept that contention unless you have to establish what degree that the central government has passed, and how that degree is in conflict with the degree you are suggesting as the state.
Indeed, your lordship. Your lordship, if I may conclude, your lordship, this particular.
So please go back and read colorable legs.
Indeed, my lord. Indeed. Your lordship, the council like to conclude by saying that this particular provision of MTP Act is to be deemed as unconstitutional as it violates fundamental rights guaranteed under Article 19 and 21, my lords. And also, it needs to be struck down as unconstitutional because there is no nexus between the object of the Act and its provisions has been stated thereunder, my lord. With this, the council would like to rest its argument and call upon its co-counsel, my lord. Much obliged, your lordships. It was indeed an honor to argue before this honorable man.
The council seeks permission to collectively address the bench as your lordships.
Yes.
Much obliged, your lordship. This council will be dealing with the third and the fourth issue. The third issue being, does the Medical Termination of Pregnancy Act violate the father's right to retain the unborn child? And the fourth issue being, does the Medical Termination of Pregnancy Act violate the right to life of the unborn child, your lordship? Moving on to the third issue, it is on the outset, it is humbly submitted that the MTP Act does not. The MTP Act violates the father's right to retain the unborn. To further substantiate this point, the council will be dealing with this in a threefold manner. The first limb of the argument, the council will be proving that the father has a right to retain the unborn child under Article 21 of the Constitution, your lordship. The second limb of the argument, the council will be proving that the procedure established by law under the MTP Act is oppressive on the part of the father and hence violates his right under Article 21. The third limb of the argument, the council will be proving that the MTP Act fails the test of reasonable classification and the same is manifestly arbitrary and violates Article 14 of the Constitution, your lordship. Moving on to the first limb of the argument, your lordship. Your lordship, it is humbly submitted before the Honorable Court that the right to life, Article 21, means something more than mere animal existence. It has been held by the Honorable Supreme Court that the right to life includes the right to carry out such functions and activities adequate to give expression to the human self, your lordship. In line with this, it is submitted thus, in this particular case at hand, the right to retain the unborn child of the father or the right to procreate of the father is integral for the father to give expression to his human self, your lordship. Taking this into consideration, the Honorable Court in the case of Jasveer Singh versus State of Punjab, the council would like to draw your lordship's attention to page 25 of the memorial, lordship, of the petitioner's memorial, footnote number 55, your lordships. In this case, the court categorically held that the right to procreate is traceable and squarely falls within the ambit of Article 21 of our Constitution, read with the Universal Declaration of Human Rights, your lordship. With me?
Yes.
In much of resolution. So, taking this into consideration, it is clearly established that the right to procreate is a right under Article 20 of the Constitution that is guaranteed to the father, your lordship. This right to procreate can be realized by the father only if the father is allowed to retain the unborn child, your lordship. If the father is not allowed to retain the unborn child and if the pregnant woman is allowed to terminate the unborn child, then his right to procreate under Article 20 will be vehemently violated, your lordship. On light of this, it is humbly submitted that the right to retain the unborn child of the father is a right guaranteed to him under Article 20 of the Constitution. Under Article 20 of the Constitution, your lordship. Moving to the next.
So you are arguing that the father should have it.
Indeed, your lordship.
To decide the termination.
Indeed, your lordship. The consent or the council's further argument will be that under the MTP Act, no consent or opinion of the father has been required by the Act. And
don't you think that is going against your own client?
Your lordship, my client is Pratap Yadav.
The other two clients. What about the other two clients?
Your lordship, for the sake of clarity, the council would like to clarify that the first council contended the Medical Termination of Pregnancy Act that it violates the right to life of the pregnant woman. My contention is that the MTP Act violates the right to life of the unborn child and the father.
Contrary, suppose this court agrees that the father has the full right over the unborn child, and the father refuses to give consent, then your other two cannot go to the court.
Lordship, the prayer at the end of the day is to hold the MTP Act as a whole as unconstitutional. So that
if we hold unconstitutional, what happened to the father's right is gone. The woman can go any time and terminate her pregnancy. you are arguing quite contradictory to what your counsel is
Counsel.
arguing.
Indeed, Your Worship. In such a circumstance,
Accept it. We accept that you are arguing contrary to what your counsel has
it's
submitted.
complementary. In fact, it's complementing my
There is no
counsel's
consensus
argument.
between husband and wife now. There is no consensus between husband and wife. Wife says she wants to terminate. Husband says he doesn't want to terminate. The MTP Act says both. As per your the counsel who argued for the first time, and then you. You say both are contrary to each other. Now, which of argument we should accept? Whether the acceptance of the counsel was argued,
First counsel or
yeah,
Your Lordship, there have been four petitions before this honorable court, and the four individual petitions have four individual prayers, Your Lordship. My contention is that under the
you're
MT,
for Radharani.
indeed not, Your Lordship. I appear for Pratap Yadav. The first,
Then we thought it was for Radharani.
no, you are appearing for all together, right? Petition.
but I represent the rights of Pratap Yadav in particular, Your Lordship.
You cannot escape by doing that. See, the issue is, suppose we hold your argument is right, we are with you, and we will write a judgment that the father has a right on termination of pregnancy. What will happen? That means you are asking us termination of pregnancy is fine, but the only thing is the father should have a say.
There should be consent which to be obtained from the father.
Indeed,
You
Your
will allow
Lordship.
the consent should be given.
Consent or opinion of the father should be required.
Both.
Your Lordship, then the council also has another. If that is done, Your Lordship, then the MTP Act, even then it wouldn't sustain because the actual
The problem is if the MTP Act doesn't sustain, then the father right is gone. That is what we are saying.
Your Lordship, even with the MTP Act, there is no right for the father.
So therefore,
MTP Act?
what you want? You want MTP Act to be there, or you want the consent of the father should be concerned.
Your Lordship, if the MTP Act is struck down, automatically the right given to the mother under the MTP Act would go away. Then
What about the father? Father also will be.
but both will be at the same situation. Equal should be treated equally
The
then.
moment we cancel MTP, the woman can walk into any hospital at any time, not necessarily before 20. Any time she can terminate without the consent of anyone.
Your Lordship, that cannot be done because Section 312 of the Indian Penal Code prevents that, Your Lordship.
Now that also we are on the channel.
I am not contending the constitutional address Section 312 of the Indian Penal Code. My contention is limited only to medical
In that
pregnancy.
case, you cannot terminate at all.
Your Lordship, even under
What is
Section
312 says? What is 312?
312 says that termination can be done if it is done in good faith to save the life of the pregnant woman, Your Lordship.
That means remaining all your contentions will go.
Lordship, my contention would not go away because my humble submission before the court is that the MTP Act does not take into account the right to representation of the father, and no right is given to the father under the MTP Act. And this violates the father's right under Article 21, Your Lordship. To further substantiate this particular argument, the council would like to direct your Lordship's attention to Section 3 Clause 2 and Section 3 Clause 4 of the Medical Termination of Pregnancy Act, Your Lordship. Under Section 3 Clause 4 of the Medical Termination of Pregnancy Act, only the consent of the pregnant woman, or if the pregnant woman is a minor or a mentally ill person, the consent of the guardian of the pregnant woman is required for the termination of pregnancy.
So basically, mentioned under Section 3. In what circumstances this abortion or termination can be taken?
Indeed, Your Lordship.
Right.
Indeed, Your Lordship.
So this is what exactly we are saying. Your co-counsel argued the other way.
Indeed, Your Lordship.
Indeed.
Lordship, the co-counsel's argument was that the MTP Act must take into account the decision autonomy of the pregnant woman. This counsel's argument is that the MTP Act must consider the father's right to the unborn child.
So you are not asking us to strike it at the NTP Act.
It doesn't consider, so it violates its right to under Article 21, and hence it should be struck down.
We can't say that.
We can